Accountant liability to third parties. No issue is more controversial than that. So let's talk about it. First, I want to state that accountants are not generally liable to third parties in contract because there's no contract between an accountant and a third party. Most of the third parties in those arrangements are incidental beneficiaries. Remember that from the contracts discussion, third party rights? So what we're actually going to be talking about here, or the cause of action we're going to be talking about here, is one in negligence. So we're talking about negligence, and when we are talking about third parties, I want you to think shareholders, investors, trade creditors, bondholders, banks, those entities or people who relied on the information that's supplied by the accountant. It's usually in their status of auditor. Remember, the most litigation against accountants arises out of their role as auditors. Think about this scenario. You purchase stock in a corporation because you're impressed with its financial prospects as revealed in the audited financial statements. Unfortunately, the auditors failed to detect that the company overstated its income. The mistake comes to light, the stock tanks. You might be able to recover from those accountants or those auditors. This type of liability does not exist with any other profession. Doctors or lawyers, third parties can't sue doctors or lawyers. It's only unique to accountants. In fact, the big four accounting auditing firms spend up to 20% of their revenue on litigation, and that includes insurance money, settlements, and the process of going through any sort of court case if they had to. I want to say negligence is governed by state law. So states have to adopt their theories. So there are three rules or theories of liability that a state can adopt in determining whether an accountant is liable in negligence to third parties. We have the Ultramares Doctrine, the Foreseeability Doctrine, and the Restatement Doctrine, and we are going to explore all three of those. The first doctrine we're going to talk about is the Ultramares Doctrine. This derives from New York. New York developed this law court case. We're going to talk about it in 1931. Other states have signed on, but this is the one that's applicable here. And the idea behind the doctrine states that an accountant must know the identity of the third party. That third party will see the accountant's work product, and they will rely on that work product for a particular known reason, that known purpose, I should say, and the accountant is the one that knows the purpose. So a company that tells the accountant, I need financial statements prepared, I'm going to turn them over to First National Bank in hopes to get a loan from them. And if the accountant is negligent or careless in preparing that under this doctrine, they may be liable. So the case, and this is actually a very narrow view, as you were going to see with the other three, or the other two views that we have coming up. This is very narrow. But in the case, Ultramares Corporation is a creditor of a company, Fred Stern, and that company sues Fred Stern's accounting firm because the accounting firm didn't uncover a $700,000 accounts receivable that were based on fictitious sales and other suspicious activity. The accounting firm rendered an unqualified opinion, provided copies of the report to Stern. Stern gave one to Ultramares, who then made a loan to Stern based on that information. And of course, Stern didn't pay back the loan. That's what happens, right? The court said that the accounting firm is not liable. Under the doctrine, the accountants who fail to exercise due care are liable to third parties only if the accountant knows that the third party will see the product and will rely on the product and know that the purpose. So it's and they know who the third party is. It's not just like, I'm going to show some bank. I mean, they need to know who it is. So as you can see, it's very narrow. Follow-up case, that case was from 1931 that established the doctrine. And the follow-up case from 1985 involves the former accounting firm Arthur Andersen. Credit Alliance Corporation was a commercial finance company, sought to recover damages from Arthur Andersen. and as they were responsible for auditing the financial statements of the company. And the Credit Alliance Corporation made substantial loans. The loans were extended based on the auditor's financial statements. Later on, it was turned out that those statements were extremely or significantly overstated, and the Credit Alliance Corporation sued Arthur Andersen. And again, under New York law, they were not held liable. The court said they must be aware the financial reports were to be used for a specific purpose in furtherance of which known party was intended to rely, and there must have been some conduct on the part of the accountants linking that to the party. So there was evidence that the accountant's understanding that the party or the party's reliance would be on those documents. So that continues to be the law here in New York State, the Ultramares Doctrine. The next doctrine is the Foreseeable Doctrine. This is the other end of the spectrum of the Ultramares Doctrine. The Ultramares Doctrine was a narrow view. It's hard to get liability on an accountant, and like I said, only a handful of states adopted that doctrine. Well, on the other end, this is the broad rule, making it much easier to impose liability on an accountant, and a handful of states have adopted this doctrine. And under this doctrine, an accountant is liable to any foreseeable user of the client's financial statements. Liability does not depend on the accountant's knowledge of the identity or either the user or the intended class of the user. So that example that I used above regarding you buying stock and using the statements to do that, if you're in a state with the foreseeability doctrine, there might be some liability there on the part of the accountant under this doctrine. So the rule, accountant who fails to exercise due care is liable to a third party if, 1, it was foreseeable that the third party would receive financial statements from the accountant's client, and 2, the third party relied on these statements. So that's all you need under that doctrine. The last doctrine, the third doctrine, is the Restatement Doctrine. Actually, it's Section 552, Restatement of Torts Doctrine. There's actually it's actually written in the law of torts, which is where negligence is found. This is the middle ground rule. This is where the majority of the states lie, right in here. The accountants who fail to exercise due care are liable to 1, anyone they knew would rely on the information, and 2, anyone else in the same class. So I'm preparing financial statements for the Topcop Corp to use in obtaining a bank loan from National Bank of New York. If I carelessly prepare the statements and Topcop Corp collapses, I will be liable to National Bank of New York under this doctrine because I know the bank will rely on it. I know what the use of the statements are for. I fit that test, 1 and 2. But let's say National Bank of New York doesn't give the loan, so Topcop goes to Bank of America with the financial statements, and later Topcop Corp collapses. Am I liable to Bank of America? The answer is yes under this doctrine because Bank of America is in the same class. A bank is a bank. I was preparing the docs for a bank. Nothing has changed. Nothing would be different had I known that it would be Bank of America. So a quick review. We have the Ultramares Doctrine, the very narrow doctrine. They know the identity of the third party who, 1, will see their work product and will rely on that work product for a particular known purpose. The Foreseeable Doctrine, the broad spectrum. At the other end, it is foreseeable that the third party will receive financial statements from the accountant's client, and the third party relies on these statements. And then the last one is our Restatement Doctrine. The accountants knew the third party would rely on the information, or the third party was in the same class as someone who the accountant knew would rely on that information. This is the one that's mostly applied. So depending on where you are in the country is going to depend on what test. If you're going to be an accountant in New York State, as you will see, the Ultramares is the doctrine that would govern any liability to third parties. Accountants can also be held liable for violations of particular state and federal laws, and we're going to discuss those in the next videos.